Good afternoon, this is Sean Golding with Golding & Golding, here to discuss FBAR Amnesty programs. The FBAR is the Foreign Bank Account Reporting Form, otherwise known as the Foreign Bank and Financial Account Reporting Form. Technically, it's referred to as FinCEN Form 114. FinCEN refers to the Financial Crime Enforcement Network. A few basics about the FBAR. It's due to be filed at the same time your tax returns are due. If you apply for an extension for your tax returns, the FBAR automatically goes on extension as well. So at the current time, you don't have to file any specific additional extension form to get an extension for the FBAR. FBAR is required even if you don't have a tax return due. So let's say you're a U.S. person, you go through the IRS website, determines based on your income, the tax return is not necessary. If you meet the threshold requirements for having to file an FBAR, you would still have to file the FBAR, even if the tax return was not due. A practice pointer I like to point out a lot is aside from U.S. citizens, legal permanent residents, corporations, businesses, trusts, estates, non-residents may also have to file in any year that they meet the substantial presence test and are considered a U.S. person for tax purposes in that year. Typically, this will include visa holders such as B1, B2, E2, E3, H1B, L1, O visa, EB5, etc., etc. So if the FBAR is not timely filed, if it's filed late, if it's never filed, if it's filed incomplete, you could be subject to FBAR penalties. And there's various types of FBAR penalties. There are the willful penalties. Those are pretty bad. And then there's the non-willful penalties, and those range. They range from a warning letter in lieu of penalty to a $10,000 penalty in total for all your misdeeds, or a $10,000 penalty per year, or if you get the wrong agent on the wrong day, feasibly they could hit you with a $10,000 per occurrence per year penalty, so that can get pretty hefty. It's not very common, we rarely see it. So let's say you realize that you're out of compliance. You want to get into compliance before you get hit with penalties. If you get hit with FBAR penalties, you can try to abate them or mitigate them, but the problem is the IRS automatically gets the upper hand. Why? Because the FBAR is part of Title 31, not Title 26. All that means to you is that you don't have the opportunity to dispute the FBAR penalty in tax court. Rather, you have to pay the full amount and then sue for refund in federal court, district court, or you have to wait to get sued by the IRS. Just kind of got to sit there and wait till you get sued, and then you defend yourself and you possibly counterclaim. Therefore, in order to avoid all of this, you may consider entering one of the FBAR Amnesty programs. There are several different programs. Why don't we go through the basics? Excuse me. If you're willful, then the only opportunity is the Voluntary Disclosure Program. There is some misinformation out there on the World Wide Web. They did get rid of OVDP, which was an offshoot of traditional VDP, Voluntary Disclosure Program. But the IRS also expanded the traditional Voluntary Disclosure Program to provide more information and guidance on offshore reporting. So if you are willful, even though OVDP has been closed, you're not out of luck. You can still do the traditional Voluntary Disclosure Program. As an alternative, many taxpayers prefer to do one of the streamlined programs due to the reduced penalty, or even there's a penalty waiver if you qualify for streamlined foreign. The two different programs are the streamlined domestic offshore procedures, streamlined foreign offshore procedures. Both procedures refer to offshore accounts. You can also have domestic income, but you have to have the offshore aspect of it to submit. When you're looking at the title of the two different programs, the distinction between domestic and foreign is the residence of the taxpayer. If you're foreign, then you meet the foreign resident requirement. For domestic, you either live in the U.S. or you don't meet the very strict requirements of the foreign residency rules under the streamlined program. There's also reasonable cause and delinquency procedures as alternatives to traditional voluntary disclosure and the streamlined programs. These programs have many nuances and pitfalls, so it's important that you research them, speak with experienced counsel, whether you're going to hire one or not, before you submit. That's the introduction to the FBAR Amnesty programs. My name is Sean Golding. We have lots of free information on our website. We have an expansive international tax law library. Our website is goldinglawyers.com. We also have a sister website devoted exclusively to the streamlined procedures, and that is irsstreamlinedprocedures.com. Thank you for your time. Enjoy the rest of your day.